Good afternoon, everyone, and thank you for joining the CMMC Launchpad Seminar Series. I'm Martin Martinez, a director at Aberrant and one of the founding members of this initiative. Our mission here at CMMC Launchpad is straightforward: reduce the cost and complexity of compliance for the defense industrial base while strengthening the resilience of our supply chain. As with all sessions, today's seminar is being recorded and will be available on demand through our YouTube channel. Please submit questions using the Q&A feature, and we'll address as many as we can live and follow up on the rest after this event. Today's discussion covers False Claims Act and other risks of noncompliance, an increasingly important topic as requirements begin appearing in new DoD solicitations. With that, I'll hand it over to Leslie to kick us off.
Hello, thank you. Just as an overview, we do this every time, just talking about a little bit about our background and why we are here and why we want to provide information. Yes, we have stuff to sell, but we also support national security and want to provide as much information as we can because we believe that it strengthens national security and the supply chain. All of us are veterans, and we have always supported national defense and national security, so we are just trying to extend that service through these offerings. We do have a guest today, named Daniel. I'll let him introduce himself. I took this from his website, so I'll let you go into a little bit more about your background because we're here to talk about the False Claims Act. I am not an attorney, so I am not best suited to present on this, but just as a caveat, none of this is legal advice, even if I were. So it's not legal advice. Don't take legal advice from webinars. But Daniel, if you want to go ahead and introduce yourself.
Awesome, thanks. You're not an attorney yet, Leslie. I'm Daniel Strauss. I work with the law firm of Cordatus LLP. We represent government contractors. We're a small shop who represent lots of service-stable veteran-owned small businesses, other small businesses. That's our bread and butter, focusing on compliance issues, small business issues, and obviously False Claims Act issues as they pop up, but they will obviously not pop up for any of the people on this call. But we're here to help you get through that and to make sure that you stay on the right side of justice, whatever that means in 2026.
I was right to unmute. Yeah, we will go through what the False Claims Act means historically, even if it's not necessarily present day situation. So teeing up the False Claims Act, I wrote a paper on this in law school, which is where I pulled most of this information. But the False Claims Act started or came about back after the Civil War, during Reconstruction. Defense contractors were screwing the government. So the government passed this law. They have strengthened it over the last however many years to make it a little bit harder to screw the government. But essentially, the False Claims Act establishes two different types of liability. By the way, before we get too started, if anybody has questions, if they want to put them in the chat, we can answer them in real time. I'm hoping this will be pretty informal to make this as conversational as possible. So, Daniel, do you want to give it a brief overview about the two different types of liability, or two different ways that they can create liability, either through submitting claims for payment, but also the records or the statements that they're providing and what the differences are in those?
Sure. So generally speaking, we're going to start on the second part, which is false records or statements. The world I live in and the world that we're going to live in here a little bit is what happens when you enter into a government contract is you're making representations to the government about hosts of things. Maybe you're an 8A company and you're representing that you're an 8A. Maybe you're an SDVOSB and you're representing that you're 51% owned or more by a vet. Part of those representations are going to include, have started to include cybersecurity issues. And so you are going to represent that at the time of contract award, at the time of proposal submission, depending on what we're dealing with, you are compliant with whatever cyber requirements sit in that particular contract. And I don't want to claim to be, well, Leslie doesn't want to claim to be an attorney. I don't want to claim to be a cybersecurity expert. I am not. I am an attorney. I know just enough to, as I said earlier, to call Leslie, but not enough to actually know everything. So I don't want to pretend that I can sit here and know all of the requirements that are sitting out there for contractors, but suffice it to say that there will be representations that you will be making at time of proposal submission, even at time during contract performance, that you are doing certain things to comply with whatever the law says today, tomorrow, in a month. those statements can be used to say, we gave you this contract award on the basis that you were going to comply with requirements X, Y, and Z, whether it be a small business requirement, a cybersecurity requirement. Separately, the government has taken the position that every time you submit an invoice to them, you are attesting to all of the prior representations again and again and again, such that each invoice that you submit constitutes a representation to the statement you made previously, which allows the government to basically look back to try and collect every dollar on the contract, because every dollar every dollar spent by the government was made under the premise of a false claim. Those are generally how we look at it from our perspective, and all of this will impact how the government tries to recover on the other side.
Yeah, so you said something about submitting a proposal. So when you submit a proposal, does that count as part of a record or statement that could be
100%.
included? Yeah. And
100%.
what
Yeah.
happens if like something that you represent in a proposal is different from, when you submit an invoice in the future? If like what happens if what you have sent them is different and they don't notice or they haven't said anything?
You, as a contractor, have an affirmative obligation to, if you've made a representation at one point that is material, and we can have discussions about what material means.
We have a slide on that.
I know we do. I looked at them ahead of time, believe it or not. We'll have conversations about what material means, but if you've made a prior statement that is material, that is effectively allowing you to submit invoices, and you continue to submit invoices without notifying the government of the change, then you have a problem. So I think I do more of my false claims work in like the small business world. And so if I submit a certification on day one of a contract that I don't have a conflict of interest, and I continue to submit invoices and I continue to submit invoices, but then it turns out 1 year into the contract, I wind up with a conflict of interest, and I don't tell the government, by the way, here's the conflict of interest. I run the risk that all of my invoices after that point are false claims because I made a prior statement that is now false, that everybody was relying on in order to keep the work going. Now, I can very much make that representation and still argue everything's copacetic, everything is fine, I should still be able to perform and still get paid. I'm not having a false claim because I have a conflict of interest. I'm having a false claim concern because I didn't disclose the change in circumstances. Does that actually answer your question, Leslie?
Yeah, and my next question would be, what's the like form or format of notifying the government of a change like that? Something that's not necessarily like part of your invoicing or part of your statement of work. How do you notify of these changes?
I will say that part of this is really fact specific as to how you want to do it, right? Like, are we talking about something existential? Are we talking about something that just kind of popped up? Are we talking about something? Do we have a good relationship with the contracting officer? Do we have a bad relationship with the contracting officer? My general rule of thumb is, assuming I can get away with it in a reasonable form and fashion, I want to keep things as informal as possible, right? Like if I'm talking about something, again, materiality will play a huge role here. If I'm talking about something small, like, hey, I said that I had the X, something minor, but really I don't, because it burned in a fire 2 weeks after I submitted my proposal. But by the way, I've replaced it with the exact same machine and it does the exact same thing, but you would ask me to represent to serial number blank. Like, I'm throwing that in an email, right? Like, nobody really cares about it. If I found an OCI issue that I need to provide some depth to explaining, I'm probably putting it in a formal letter, so that it can go sit in the contracting officer's file somewhere, so that I can make sure that if somebody were to come knocking on my door, that I can say, look, here's what I did, here's how I did it. This got me to exactly where I needed to be to not make a false claim. But
Does
I
it
think, yeah,
does it have to go to the contracting officer or can it be like your project manager on the government side?
I always want things to go to the contracting officer because I don't want there to be any argument that I tried to skirt around something, right? Like, we can absolutely send it to a project manager also. We can send it to both of them. We can send it to the project manager and maybe forward it to the contracting officer. But I think I think the safest approach will always be to get things to the contracting officer because that's the only person who can make a decision. And absent them having knowledge of it, the argument would be that the representative for the government doesn't have the right to make a decision. And so if the person who makes the decisions on the contract doesn't know what it's making a decision on, then it can't actually make an informed decision. That was decision like 12 times in one sentence.
Yeah, no, that my GovCon professor, every class at least 3 times said only the contracting officer has the ability to bind the government. So if they make a decision, that's the decision. If anybody else makes a decision, it doesn't count.
Exactly. And so like,
Yeah.
sure, I can make an argument, like, of course, the contracting officer knew, and we've made these arguments before, right? There are times that we say, well, yeah, we didn't formally tell the contracting officer this, and this is a lot more in like the changes area than in the false claims area, but we didn't tell the government contracting officer that we were doing this particular work, but the contracting officer came to the site, saw us doing this work, and basically acquiesced to it, right?
Ratified it.
That's hard. That's
Yeah.
harder in the context of like CMMC compliance, unless they're like sitting over your shoulder while you're getting audited. But at least in theory, if there's some basis to argue that the contracting officer knew or should have known, then we can have an argument that doesn't matter if you tell them. But the safest and most compliant approach will always be open and transparent communication. And I will tell everybody on this call and who listens on YouTube later, it always seems better in the short term to say, oh, well, there's money to be had now, but I promise you the lack of sleep and dollars to me and whatever other lawyer you decide to use will ultimately cost more than that. It just doesn't seem like it's much easier to forego the short amount of work you're going to lose, rather than dealing with on the other side.
Okay, I have this is not meant to be a gotcha question. If you don't know, that's fine. But with regards to like reporting your self-assessment score in SPURS, right? Like the 110, whatever. If you have a score, it's 110, you win a contract, and then like 2 months later, you just go in and update your score to, negative 200. Let's say that's a pretty significant drop in points. Does that count as meeting meeting that requirement? Like, okay, actually we weren't compliant, we're fixing our score. Do you then need to like circle back with your contracting officer and be like, just wanted to let you know? Or would updating the score be sufficient?
Was the score you had initially accurate? Like not accurate because it changed, but was your
Let's
score
just say it
like
was. Let's say, yeah.
like you had a reasonable basis upon which to score 110, and then oh no, something happened and now you're at negative 200.
Yeah.
I don't know, but I think the SPURS goes back to the government. So I think it constitutes a representation on its own, the same way like a SAM.gov representation counts on its own. So I think that can count. Typically in the moment, all you have to do is report your score, right? And so the government's not basing an award decision on what your score is unless it's an evaluation factor, right? So the government's just saying, okay, cool, you're doing it. Today you're just taking care of getting a score for yourself. And whether your score is 110 or negative 200, it doesn't matter. We aren't basing our decision on your current score. So I'd argue that it's probably enough to tell them that, unless your contract includes a clause that says notify us if your score changes or notify us if there's a material change in your score. And then I'd make the argument, if somebody were to knock on my door, I would make the argument that it's fine, we just updated the SPURS, but I would probably tell a client talking to me about it. Again, that goes in the informal, let's just send an email to the contracting officer and say, hey, FYI, our score is negative 200 now. And in an ideal world, that goes from inbox to cyber advisor file and goes away and nobody ever looks at it again, but you've done your job. In 6 months, in a year, when it becomes like a mandatory, you need to have X score and you fall below that level, I'd probably make the argument that you would want to notify the government more formally than just the SPURS, because you don't want somebody else coming back with a gotcha, or a competitor. You don't want a competitor going to the government knowing this change and saying, by the way, have you heard this about this company? You want to be ahead of those things so that you're not playing defense.
So what about, and I've had, had some folks disclose this to me, which is one of the reasons why I went to law school, where they reported a score of 110 because the person that did the assessment didn't really know what they were doing. And now that we have more information, it's become very clear that going through the right processes, they don't have 110. So their previous score was actually wrong, not through like malicious intent, but through a mistake on their part, and they reported it. Now they've done a self-assessment and their legitimate score is much lower. What do they do then? Like, obviously they should report their updated score, but what do they do about their previous score that was not accurate?
I don't know. Like I think you and I have talked about this offline, I think a little bit, and I think my answer then was the same too, which is it's complicated, right? It's relationship based, it's dollar based, it's again, I think we can make a reasonable argument that none of it's material as of today because none of it is actually impacting what the government is making an award on. And so, yeah, even if it was totally off base, even if it was made up, at least from a purely government contract false claims act case, the government has to be relying on it, right? The False Claims Act has a reliance requirement, right? So if the government's not relying on it, then it doesn't have any sort of materiality associated with it. Whereas if you say, I am a service disabled vet and you've never served in the Army or the Air Force, then like you shouldn't be getting service disabled vet work. And so like that's the kind of thing that we're looking at. But again, if you've lied, if you've gotten like some fraudulent auditor to do this for you because the government's going to rely on it, then you have a problem. And obviously, none of this touches like the commercial world problems of you've told somebody this and they might be relying on it. But at least in the False Claims Act sense, I think that you're probably okay today with changes afoot.
Okay. And I think is the next slide. No. I'm going to jump ahead to materiality because we've already like talked about it a bunch, and I think it's apropos of this whole conversation. So can you tell us a little bit more about what it actually means to be material and how how companies could think about this from their perspective?
Sure. I think when you're talking about material, you're talking about the things that induce in any context, induce the government in this context, but induce the government to enter into the contract with you as opposed to somebody else. Things that would make you eligible versus ineligible for the contract. Things that in easier context, invoicing, like you're invoicing the proper amounts. You're represent if it's a time and materials contract, you're not saying you worked 45 hours if you only worked 40. That when we get back to the first slide of what are the types, like if you're submitting an invoice with a false amount of money for work you didn't perform or for somebody who wasn't qualified according to the specs, but you certified that they're qualified, that's when you run into issues. If you in the CMMC context, if the question is, have you used a 3PAO to do your audit and you haven't, then you've certified to that and the government's relied on that. Regardless of what your score is, they've at least relied on the fact that you're using some reputable company to run an audit for you. So materiality is really just, is the government getting what it asked for, or are you skirting those rules? It's generally, I know that's pretty layman's terms for it all, but that's generally how I try to think about it, right? So it's not material what your score is, but it is material that you're reporting your score because the requirement is that you're reporting a score. And as long as you're reporting it, then you're okay. But if your score is negative 200 versus 110 right now, that's probably not an issue.
Yeah, but at least for me, and I'm not a contracting officer, nor have I ever had to think about withholding payment, but it seems it would be material to me to know that a company purposely lied about either having a third party assessment or, change their score from 110 to negative 205. That would be, seems to me like a red flag, not that the score was negative 205. If it was negative 205 in the beginning, okay, I would have awarded the contract. But if they came to me and told me, just kidding, I wasn't telling the truth, we didn't actually have that score, our score is actually much lower than it was, can that like create materiality? Like the act of
Only if
like,
only if the
you know,
gov not really in the False Claims Act context, right? Which doesn't make you free and clear. I'm only talking about the False Claims Act context, right? So if the government didn't rely on the score that you had and just relied on the fact that you had a score and you reported it, and again, I'm assuming things like the basics, like you didn't just say you had a score, but you didn't just throw a number out there because you needed to put a number, but you've actually conducted some form of audit, some form of assessment, some reasonable basis upon which that score comes from, that then, and it turns out somebody made a mistake or you inadvertently forgot something, then I don't really have a problem from a False Claims Act perspective. Again, because the government's not making an award based on what your score is. But if you've lied to the government, if you've said you have an audit and you don't, then we're kind of in the False Claims Act sense, right? Then we're in the, you told me you had this score, but there was no real basis for that score, right? It didn't come from anywhere. And so you didn't actually do what you were supposed to do, which is find a way to get a score, self-audit, auditor, whatever you might be, level one, level two. Like I don't, it's irrelevant. You have to be doing what you're supposed to be doing. Um, and so you can definitely have a conversation with that contracting officer about whether you're responsible to continue performing, and the contracting officer can have a conversation about whether that's a breach of contract. And it very well may be a breach of contract, but from a materiality False Claims Act standpoint, if they're not paying you because of your score and they're not paying you because you had 110 and there was no threshold for what your score has to be for that contract, then there is no material, or at least I would argue that there's no materiality for that. Now, I wouldn't be surprised if the Department of Justice decided to take a position at some point that, hey, that was material in some form or fashion. And then clients have to decide if they want to have that fight or not versus paying whatever fines associated with it, and always be honest, transparent, and clear with what you're doing and how you're doing it. But at least from a False Claims Act perspective, I don't think that would make it material, provided that there was nothing in the solicitation that put you or the government on notice that that's how they were going to make their award decision.
Wouldn't materiality be breach risk though? Like, wouldn't that be material?
Materiality in terms of the False Claims Act, or materiality in terms of a breach of contract?
Well, in terms of the False Claims Act, because if I claim that I have a cybersecurity posture that mitigates or, that reduces the likelihood of a breach on my part, and I basically misrepresented myself or misrepresented the security posture of my company in order to win the contract, then the government is
Are we using the word
harmed.
breach in two different ways? I
are.
think Joe may be using
Yeah.
like
I don't mean
cyber
in
breach
terms of a
versus a
contract.
contract breach.
Yeah.
Yeah.
Yeah, I meant it in terms of a security breach.
Yeah, no, I
in
got
terms
you.
of- yeah. But like if I misrepresented that I was like, more secure and I was given information, or that I was a steward of information that was sensitive, and I was glib about the controls to secure the information, isn't there a material harm to the
So I
government in that
think,
case?
so I think we're actually saying the same thing. Um, the world that you're speaking in, at least as I'm understanding it, and tell me if I'm wrong, we met 20 minutes ago. But the world in which I'm speaking in, the contract would have had some sort of requirement that you have a certain security posture, right? And so if you're misrepresenting the security posture that's a requirement in the contract, absolutely that's material. But if your contract just says you have to be preparing for CMMC, and currently that just looks like posting your scores and your scores, then whether you've told me you score X or score Y is irrelevant. But to your point, if there's a contract in which you're getting information that requires a certain level of security that you're misrepresenting, absolutely that's
Well,
a breach.
in the CMMC case, I might be attesting like that I've essentially done a self-assessment and that I meet the standard of the CMMC 2.0 or level 2. Does that make sense? So like,
Help me,
yeah.
because this is where my lack of cybersecurity matches where I am, right? So to me, what you're attesting to is that you've conducted an audit and you've reported your score.
Yes. And that it meets the standard to say that I have, that I'm compliant with, CMMC 2.0 level 2.
Leslie, help me.
Yeah, so I don't think the government actually cares because the government has said, so the government uses NIST 853 for their information systems, and they have distilled and divined the equivalent contractor requirements to implement on their networks to have the equivalent level of security, right? Like the impact level moderate for CUI. So NIST 853 at the moderate level for government, 171 for industry. And as long as you've done the scoring and you've done like the whole process, that to the government is equivalency. So if you're not actually doing what you tell the government you're doing, is that material? If they don't care if your score is 110, they don't care if it's negative 205, as long as you have a score that
Correct.
checks a box. And I think this is evident, unfortunately, in the settlement that we saw with the Georgia Tech case. I did an externship last year with Julie Bracker. She is a whistleblower attorney, and she represented that whistleblower, and she also represented the whistleblower in the Penn State case, which is why I went to work for her, because I saw her name and the way her complaint was written. It was fabulous the way she talked about cyber. But they ultimately settled for around $1 million, like maybe a little over $1 million. And I wrote a whole paper on Georgia Tech, but Georgia Tech had several contracts with DoD agencies. I don't remember which one, but they were doing like really sensitive research into cyber tools to like create cyber tools to hide what we were doing in adversarial networks. Like if we're hacking somebody, we want to be quiet. That was a level of research they were doing at Georgia Tech, but they had no SSP. They had not done any of their self-assessment, but they had been attesting to the government that they had been. So they were in a cyber lab with no cybersecurity controls, and they said they couldn't do it because they needed to throw all these tools on their environment that would have like flagged a bunch of, security tools. So they were like, we can't do the security. We have to have our lab. We're doing cool, fancy stuff, but they're attesting to doing all the things through their, contracting arm. And they weren't doing any of it. And they settled for $1 million, like including the whistleblowers cut. So the government did not seem to think that cybersecurity, like doing zero cybersecurity, was not that big of a deal, or at least there were not damages or harms that they found in that case, which was
There's a
crazy.
subtle difference. Yeah, wouldn't the difference be that they maybe believe they were, but misrepresented the fact that they really were?
Oh no,
'Cause I'm-
the lab director wrote, like there were emails from the lab director back and forth to like the contracting office and was like, we're not doing this. We don't have to do this. We're exempt
Yeah.
from this. And they were like, no, you have to. It's in the contract.
I
Are you
think
guys
this is-
familiar with Morse Corp of 2025?
I'm not.
It's a DFARS case where it was like they're supposed to basically adhere to 800, 171, and they made false claims, and then they received a damage of like I think it was a $4.6 million penalty. And I know these are like it's infrequent that it happens, but it is like a case where like what I'm saying, it was like a misrepresentation of their posture. They had submitted to SPURS and they had lied. And so the government came back and whacked them. So I was like, yeah.
So lying's a different world, right? Like
When I
But
say
when I-
misrepresentation, I mean lying, I guess. Yeah, that's
yeah,
like
I'm
yeah.
with you, but there's a difference between, to me, there's a difference in saying we have 110 because we decided we have 110 because we wanted to market ourselves, versus we went to a company, we have 110, and oh man, we went to another company and it turns out it's actually negative 200, and the first company was totally making up that they had any sort of cybersecurity knowledge. I do think there's a fundamental disconnect with my cybersecurity friends, because my cybersecurity friends want actual cybersecurity, right? They want a world in which things are secure, in which confidential information is protected, in which CUI is protected, in which all of the right things are happening. And the government's like, oh, we have to slowly get there. Like in this slow but sure way, we have to make sure that the contracting force actually is able to do that. And like some of that just comes through NIST, and these companies all say they comply, and I don't know if they do or don't. But I think the difference is your world is really focused on dummies, you have to be cyber secure, and my world is really focused on, man, we just have to hit the requirements, and right now the requirements don't actually require us to be cyber secure, even though that's totally silly in
Do you,
2026.
do you know if when DOJ starts investigating a whistleblower complaint, do you know if they talk directly to the contracting officer to ask about these materiality type questions? Because if it's not material to the contracting officer, like it doesn't really matter
So
potentially.
yes and no. I think it depends on the case. I don't think they're actually talking about materiality to the contracting officer because I think materiality is typically built into solicitations and contracts, right? So if, for example, let's just keep using the 110 versus negative 200. If, for example, the contract says you need to have a score reported through a viable, reasonable audit, cool, right? We did that. But if the contract says you needed to have 100 or higher, then it will make a difference. The contracting officer might say
Mm.
to the Department of Justice, yeah, they had 100 and I relied on it and it made me feel really comfortable giving them the work. And had I known they had a negative 200, then I wouldn't have. And maybe that's true, but I would argue from the defense side, what does it matter? Like, sure, maybe you relied on it, but I had no basis to know that you were going to rely on that score. What your contract told me was I just had to report something. So why does it matter whether I had 110 or negative 572? Um, I I don't know if I would win. I think there would probably be a settlement somewhere in the middle, which is why you're seeing these $1 million settlement cases because the fights become more expensive than the settlement dollars and the risk of having an actual judgment against you is different than saying we don't admit liability and we pay the $1 million if we can afford it. But I think that I typically try and focus my material assessments on what does the actual contract say, not what does somebody randomly say they relied on. And I think when the Department of Justice starts focusing on, well, this is what we relied on, what if it's not on paper, then how was I supposed to know they relied on it? How was I supposed to know that that representation was material to you because you basically told me it wasn't.
I have to admit,
Yeah.
I'm really
So
confused about like the notion of like there's sometimes it's unambiguous. Like, for example, if there's a control that says I have to be compliant with FIPS 140-3 and I'm not, it's not like it's basically a requirement that I do and I'm not, it's a binary. I am or
That
I'm
that
not. And
that's
yeah,
material. That's material to me,
yeah,
right? If you tell me you're NIST compliant and you're not NIST compliant, material.
yeah,
but
If
that's what
okay.
you
the score is, right?
That's what
Like,
the
and that
score is. Yeah.
I
That,
don't think the government I don't think contracting officers by and large are looking at it like that yet, right? Like
they're not.
I went to an army school just a couple summers ago, actually before law school, and one of the women in my class was a contracting officer, and she's like, "Oh yeah, that CMMC stuff, that's just a check in the box. Like I just check to make
Yep.
sure they have it, and I move on." And I was like,
Yep.
"Well, first of all, it doesn't exist yet, but sure." So
Yep.
until they start understanding that a self-assessment is fundamentally different than a third party assessment, and then a score of 88 could potentially be materially different because of not using FIPS encryption. Not even, you can have no encryption and still have a score, right? Like over 100. So it's kind of, I don't think the KOs understand that level of detail when it comes to cybersecurity. I think for now it's
So
not a
so
material.
so I think that the way I view it, and you guys please correct me if I'm like off base on the cybersecurity side. Like the way I view it is CMMC is treated differently than NIST, even though you guys tell me it's the same thing, right? And so most contracts that are dealing with CUI or classified stuff like have some sort of NIST requirement in it. Um, if those contracts exist and if somebody says in those contracts you need to be NIST compliant, I don't know fully what NIST compliant means, but if it says that and you're not, if you can have a score of negative 200 and be NIST compliant, great. If you have to report a score that somehow doesn't meet whatever NIST compliant means, then yeah, if you're representing a score that doesn't meet what the contract actually says you have to do. But my understanding, and again, maybe this is just a contractor's perspective, and a contracting officer's perspective, is right now the rule is just give me a score. Have conducted an assessment, some level 1 self-assessment, level 2, 3 PAO assessment, like cool, have that done, and whatever your score is on the other side doesn't matter. That said, if there's a separate requirement to be NIST compliant, to have FIPS, to do whatever, and you're not there, then yeah, that's a material breach. Then you are misrepresenting what your score is. But I think I think we're talking through like different understandings of my world and your world.
Well, the DoD introduced a whole world of complexities that did not exist before the SPRS score, because no other agency has a score associated with NIST compliance. Like there's not even the FAR that doesn't even have a CUI rule. It's DoD and some other acquisition supplements across the acquisition world, but there's not like a general FAR requirement currently. I think they've been working on it since 2017. So being NIST compliant differs inside the DoD versus outside the DoD currently.
Right.
Also, GSA just published some guidance where they're going to start requiring revision 3 for NIST 800-171, which kind of screws the CMMC because that's revision 2. But so outside DoD, NIST compliance means one thing. DoD assigned a score for your NIST level of NIST compliance, but you can literally have the most negative score, like miss every single control and be negative whatever, and still technically have done the SPRS scoring and reporting thing. However, the CMMC is different. So they have the CMMC cell for C3PAO. It doesn't matter because the scoring is the same. For that, you have to be 100% compliant to have like the full CMMC level 2 self or C3PAO. They allow you to have some gaps, but they tell you which controls can have gaps, and then you have to have a POAM, and they have to be closed in 180 days. So if you're saying that you have it's called like an interim or provisional or whatever it's called, it's an allowable status that you can win a contract with. It's unclear how the government follows up to make sure that those POAMs are closed out, but that's the only place where it has very specific controls that can and cannot have gaps. Would lying about one of those gaps be material? Right? Like if they said, we're level 2, but provisional because we have gaps A, B, and C, but really they have like gaps D, E, F, and G that are not allowable.
I would argue that would be material, right? Like if you're telling somebody, if you're withholding gaps that you have, then that would be material. Now, if you went through a legitimate process and somebody didn't see the gaps and then later you found them with a different audit, then that's probably, I would still argue it's material, but it's probably not a false claim. But absolutely, if you're representing to the government that you have A, B, and C done and you really don't, that's problematic. That would be material.
Can we talk a little bit about the CENTER requirements? Like, how far down, or to what level is somebody who's making the attestation? How much due diligence are they supposed to be doing to be confident that their SPRS score is legitimate, right? Because I imagine, VPs or principals, whoever are signing contracts, are they going and checking with their cybersecurity team to make sure that this SPRS score is accurate before they're reporting it or signing a contract? Like, are they going to be, can they put their head in the sand and say that they didn't know?
They can't put their head in the sand and say they didn't know. You have to be doing what I would call ordinary course of business. At least is and that's not a legal term here. But like if you're doing ordinary course of business due diligence, if you've done an audit and you've assessed the company and you got quotes from 2 or 3 different auditors and this is the one that seems right, or your friend Leslie sent them to you because she's done that her whole life, like great. And they haven't ignored anything and you don't have some sort of side agreement to like hide information, then you're probably fine. But I think the issue from a liability standpoint and from an intent standpoint is, are you burying your head in the sand either truly or just by not looking, right? Like, are you just actively walking the other direction? your head's not in the sand, but like isn't gonna work. You can't ignore red flags that are sitting in front of you. Um, Guy gets investigated by DOJ for being a fraudulent auditor. You can't be like, oh, I had no idea this guy was crazy and was going to give me a bad score or an inaccurate score. But you don't have to like turn over every stone to make sure that you're not there. Again, the business, it's easy to say all of this from the attorney side, right? The business side of me is that the Department of Justice is going to knock on your door if they think you've done something wrong. And so where you put your head on your pillow is what matters, right? You have to be comfortable that, man, I really did everything I felt comfortable with to get to where I am to make all of these representations. They're real representations. They're important representations, right? Like if something gets breached from your system, you want to be able to say, man, I did everything right. Um, because not only are you dealing with a false claim act, then you're also dealing with, by the way, the whole system got breached. And so we need to make sure that you're doing your diligence to protect the government and to protect the government's information. And so that, like, if you're doing those things, ideally you're avoiding any sort of burying your head in the sand. And if we have the government's mission in mind, then we'll get there. And maybe that's idealistic that we actually have that. But to me, that's where it sits. If you're doing your business diligence appropriately to make sure that you're going to meet the government's mission, then we should hopefully be okay.
Yes, and I want to, before we get into penalties, I want to talk a little bit about key tam, because that seems to be what gets into the news. There's been other False Claims Act cases involving the DFARS 7012 clause and cybersecurity, I'm sure. I haven't had a chance to go look at them, but I know in the first like 3 False Claims Act cases involving the DFARS 7012, they were key tam cases. Can you talk a little bit about what key tam is? Or
Sure. Sure. So I feel like I'm talking a lot. If anybody else wants to talk, they're welcome to. If
Well, you're the lawyer here.
this is why we get a bad reputation for talking too much. If a company, we'll use a company, a key tam lawsuit is basically in which an individual goes to the government and says, hey, I know about a false claim. It's filed under seal, meaning that the public can't see it yet. The government then gets to investigate. Oh, look at this. I wasn't even looking at the slide, but I was talking right
Good
down
job.
we're on the same team. The government then gets to investigate that false claim and decide whether they want to handle the case with the Department of Justice or whether they want to allow that individual to pursue that case on their own. That comes after time. It comes after lots of negotiation and discussion. Full disclosure, I've never actually represented a key tam relator. The relator is the person who files the lawsuit. I often am more on the defense side of these things. But what you're looking at is somebody who knows information that is not publicly available, that is not otherwise disclosed or fully made public in some form or fashion, that the individual knows. And the CMMC requirements are like perfect for it at the moment, right? They're the perfect world of nobody else is going to know. But man, I was in the room when we said, let's say we're FIPS compliant and we're not. Let's say we have done an audit and we haven't. Yeah, let's say you're in the
The first 3 key tam DFARS 7012 cases, in all 3, well, I know at least 2. I don't remember the Penn State one so much, but I wrote a research paper on the Georgia Tech one, and then I did some consulting around the first one with Aerojet Rocketdyne. And in both cases, those 2 cases, it was the cybersecurity people who were telling their bosses, we have this issue, we have to fix it. And again and again and again, their leadership said no or brushed it under the rug. And they, out of frustration, went to a lawyer, because you have to go to a lawyer to file this complaint under seal. And that's what led to the key tam. It wasn't that there's just, this greedy little IT guy who's sitting in the room and sees that you're not FIPS compliant and then runs to the government. It's like they're trying to fix it.
No, it's somebody who's trying to fix a problem.
Not.
Being a relator is a lot of work, right? It comes
And they
with
lose their
good,
jobs a lot of the time.
it comes with
Yeah.
good rewards on the other side if we get all the way through and if there's a penalty and if it works. But otherwise, you're looking at it's why it's filed under seal is to protect that person and their job, right? It's filed under seal because Leslie goes to work for Ford. And I don't know if you've ever actually worked for Ford. If you have, I'm sorry, it was a bad example. So Leslie goes to work for Ford, and Ford is selling to the government, and she says, "Hey guys, you have all of these problems," and they're like, "Nah, we don't really have all of these problems. Don't worry about it. Go away." And you do this day after day after day, and you're like, "But we're making these representations." Like you're going to get frustrated because you were actually trying to do your job, the thing that they paid you to do. But what they're trying to do, and no disparagement to Ford, I'm just using them as an example, but what they're trying to do in this particular hypothetical is they're trying to hire you so that they can say, look, we have somebody who's doing all of this stuff, and you feel like this 150, $200,000 pawn in their game to make multi-millions of dollars. And you say, enough of that, this is against the rules. And you go forward, right? Like you have it's not to say that all key tam relators are like those perfect do-gooders who are trying to do it right. Like I've represented cases where like an ex-wife has been a key tam relator because they know a bunch of stuff. I've probably represented ex-husbands who have done the same thing. It doesn't make them any more wrong either, right? Like they are right. Magically, they waited until after they got divorced, but like it's all sitting there. So the question is your case strong enough that the government wants to take it? Otherwise, it's going to cost you a tremendous amount of money to do your own fight, to do your own discovery, to make sure that what you have is right. And so when you're writing these kinds of key tam cases, what you're trying to do is get as much detail and formal information as possible. In the CMMC case, at this point, it's probably fairly straightforward. Again, I haven't represented anybody in them, but it's probably fairly straightforward right now.
Yeah. So I tried to put some things together to kind of show where the liability could arise, I guess, as part of the CMMC and all of the either implied certification through submitting your invoices, but also the false records or statements, because it's not just the statements you make, but it's statements that you make to someone else that they rely on and then submit a false claim. So if you're submitting like a false C3PAO assessment to your boss, and then he's going and attesting, in Spurs or whatever that they have something, he's relied on your materially false statement.
As significantly a subcontractor, right? Like if you're a subcontractor representing to a prime contractor and that prime contractor is relying on your statement, the subcontractor can still also be liable for the statements made by the prime, and hopefully your subcontracts have some sort of indemnification clause in them. But know that the flow downs can go both directions.
Just bring in an impleter.
Oh, you're studying for the bar.
Um,
I don't even know
so
what that is.
I did really good at learning the difference between an impleter and an interpleader, bringing like a third party, bringing in two parties to fight versus you as a defendant bringing in a third party who has liability. Speaking of third party liability or even yours, what are the types of penalties for violating the False Claims Act? And what does treble damages mean?
Sure, let's start with treble damages. Actually, let's start with something that's not on the slide, which is at least in the government contracts world, the government's general big picture position is you're responsible for every dollar on a contract in which you made some sort of false claim. So every invoice counts as a statement that makes the same false claim, and it's not just that we're entitled to process, we're entitled to payment, sorry, profits. We're entitled to all of the money, such that even though you only actually made 7% profit, you actually owe us every dollar on the dollar because that's what we paid for. We can have those discussions at settlement into what that looks like. But then as to treble damages, on top of paying every dollar, regardless of profit, the position in the False Claims Act is you're actually liable for 3 times that amount. And so if you have $1 million contract and you said that you completed your CMMC assessment and you didn't, and the government says, okay, we relied on the fact that you said you were NIST or you completed your CMMC assessment and you actually didn't, and that's material. I know you only made $100,000 on this contract, but you're liable for $1 million because that's what we paid you based on that, and you're also liable for $3 million instead because we have the statutory authority, and it's statutory to go after treble damages. In negotiations with the government, they're willing to have discussions about whether they should get treble damages or not treble damages or two times. And that largely becomes where you can negotiate what those numbers look like. But as your last bullet, and what we didn't talk about fully on the last slide here is the government sometime constrained when they're taking a key tam suit versus a suit that they find on their own. Because this relator is sitting out there expecting to get 15 to 30% of whatever the recovery is, and they've given you this case on some semblance of a platter, which doesn't mean that there's not real work to be done on the other side, but they've given you the case that you didn't have to find on your own. And like, wait, you're only going to settle for $1 million and you could have had three? Like, why? What is the basis for that? Because I was going to get 15% of $3 million and now I'm only getting 15% of $1 million, and they want more. And so that does have to play a role in the Department of Justice. I got off the phone with the Department of Justice yesterday on a case where part of the conversation is how do we do this in a way that makes sure that the relator is getting real money associated with their case.
And what's the difference between damages and penalties? Are they the same thing?
I don't think of them as different, but you can tell me I'm wrong.
No, just because of damages being like actual damages tied to like the contract versus penalties
Oh, sure.
per violation.
Yeah, I mean, you're entitled to punitive damages or penalties associated with cases in addition to damages themselves. So the damages would be the $1 million, right? You have a $1 million contract. We are damaged by $1 million because we paid you that $1 million. But for each invoice submitted, you can face a punitive penalty. There's a limit to it. It's in the five figures. I don't remember what it is. I'm sorry. But they're entitled to a five-figure payment per claim submitted that is wrong. So for every invoice you've submitted, it's treated as a separate claim. And so there is a penalty. It was $1 million, but it was over 5 years. So you've submitted 60 invoices, and now you have 60 times 10,000, another $600,000 worth of damages. It's higher than that, but I think it's in the 20s. Do you know?
Oh, I don't. And I know some of it's tied to inflation or
Yeah.
something, right? But I
Yeah.
haven't looked lately. And we only have a few minutes left, but I guess I'm gonna wrap up with cooperation, right? So if you report, are you more likely to face less damages or penalties if you're like willingly telling them that like, so sorry, we haven't done this?
So let's start at like the very beginning here with some history. In the olden days, the rule, and I don't remember what olden days means, but in the olden days, there were two different types of disclosure. There was a voluntary disclosure and a mandatory disclosure. And at least in the government contracting world, we've gotten rid of the voluntary disclosure. So technically, anytime you have a reasonable basis to believe that your company has committed some sort of false claim, you are in contract by contract required to report it. And so in straight contract world, there's no credit given for self-reporting a problem or something that you learn about because you're required to. In practice, I think that what it does is it allows you to tell your own narrative, right? I represented a client who it became pretty evident to me fairly quickly that they had committed a false claim. And so we're having discussions about it, and we're having discussions about what do we do. And we know the government's probably going to start looking at this, but the government's kind of on the wrong track, and it looks like they're on the wrong track, but I know about it. And if I know about it, like they might, like we can roll the dice and they might know about it. Or we can take the bulls by the horn and say, in the process of looking at the things your direction, we found this and we want to tell you about it. And here are all of the ways in which we want to tell you about it. And fully transparent, fully honest, but painted in the way that we want it to be painted to avoid the other side getting to go first with whatever narrative they have in their head, which isn't to say that they're not going to get to whatever narrative they want anyway, but we've gotten to present it in a way that here's where we are, here's our position, we know you're going to take yours, but we're going to be open and transparent with you. And I actually got a call from the DOJ attorney when that case was over. We settled it. And I got a call from the DOJ attorney who said, I really just appreciated your candor and the way you thought through everything. And while I disagreed with some of the things you were saying, and I disagreed with how you got there, you at least were very clear and open about what you were doing. You hadn't hidden anything. You didn't force me to take steps X, Y, and Z to get to where I needed to go. And I knew I could trust that what you were telling me was reasonable and viable. And I do think it made a material difference in what that dollar figure looked like at the end. So I always think that whether it's really a mandatory disclosure or really or not, when you have the chance to go first, when you have the chance to tell the government what the problem is, and instead of letting the government tell you what the problem is, you are at least in theory able to limit the scope of what that is.
Yeah, no, as a parent, I tell my kid that all the time. I'm like, you better
Yep.
just tell me first, because it's gonna be a lot less bad if I find it and then I'm really pissed. So yeah, that makes sense. I don't think we have any other, yeah, that was all I had, and we have like 2 minutes left. So if anybody has questions,
I think there's a couple questions in the Q&A, if you could
Oh, okay.
check it real quick.
It's not loading. Oh, there we go. What about new contracts that have the 7025 clause? So the 7025 clause is for solicitations, and it's just to say that the CMMC requirement will be in the contract. So actually, Dana, I think I sent you an email when the final CMMC rule first came out. I was like, what's the difference between the 7025 clause and the 7021 clause? And
We
it's
talked about it
because
for a really long time
yeah,
because the clauses look the same. I don't remember what we decided.
yes. But the 7025 is for solicitations only, and the contract itself will include the 7021 clause. So it's
Right.
just the notice clause.
Right.
to put in
One is
solicitations.
notifying you of what's going to exist, and one is notifying you of what your requirements are.
Yeah. Is Mitch still here? He asked a question 30 minutes ago, and I don't remember what the what we were talking about, but he was saying that can you explain the logic about all of these things not being an FCA violation when it seems like all or most of the FCA claim settlements have been based on exactly that? I don't know if the microphones can be unmuted. But it was probably back to the conversation about, not having FIPS and not having the particular controls, but having the score itself being
So remember, we're talking about settlements, right? Like we're talking about settlements. And so we're not at a place yet in this cybersecurity world where we have like clear answers. We're in what I would call like test cases, right? And so do you, contractor, want to spend the millions of dollars on an attorney to be the test case for is this fraud? And most of the time the answer is business decision is I'd rather just cut my losses, right? Like I'd rather like $1 million fine, okay, like I'll pay it, I will move on. I probably made some mistakes. I've probably done things that I should have done differently. I don't think it's reasonable. I don't think the government is right, but man, I'm just going to move on. I had a not related to cybersecurity. I had a case dealing with set asides and joint ventures. And I am 100% certain that my client was on the right side of it. I actually had the DOJ attorney when I said to the DOJ attorney, can you please tell me what law was violated? And she said, well, you violated the spirit of the law. And I said, but that's not really the rules, right?
Yeah.
But then the question becomes, okay, how long do I want to fight about whether my violation of the spirit of the law really was a violation of the law? And what happens if I get a judge who decides that the spirit of the law is enough, even though I don't think it's enough? And so you're in a spot where, okay, like, yeah, company X lied, right? They told some sort of untruth and somebody got really mad about it for some reason. And here are my choices. My choices are I could explain it in 3 or 4 letters and get to a number that I can live with, or I can go fight the unlimited funds of the Department of Justice and the unpredictability of a court. And am really unpredictable in this world because there's nothing out there on it. And so,
right. the Aerojet Rocketdyne case, the first False Claims Act case involving the DFARS 7012, settled on the first day of trial, right? It was all about their cybersecurity. Did they have the right controls? And literally they played chicken all the way up to first day of trial because they didn't want that to be, they didn't want to be the test case in court to determine what's going to be material versus not.
Right.
So
And I actually just pulled up that press release, right? And so, like, first of all, you have a key tam, right? So somebody else has money on the line. But the press release actually doesn't say very much at all, right? When you look at the press release for the case, it just says they agreed by misrepresenting its compliance with cybersecurity requirements and certain federal government contracts, right? It doesn't say anything about what was false, what was actually done, how it was done. So the government in its response doesn't actually give you any information. Now, the world might know more because people talk and the world talks, but the Department of Justice's formal document that says, hey, this is exactly what happened. Obviously, it also comes with the bottom line that says, by the way, this was not a determination of liability.
right.
Like, sure, did they do things? Could they have done things? Did they probably lie in some way? What did they say in what form? I don't have any idea. Maybe you guys know because you live this world. But I don't have any idea what was said, what the context was, how they got there. But I'm certain that being the one on the last day, right before trial, to be like, okay, finally we got to a number that works. Do we really want to take the chances? I don't know what number was what the government would have been asking for $100 million, right? And so $9 million in a case where you might lose 100 million might sound really good. I don't know how
Yeah.
much they spent to defend it in the first place. Like, you just get to a point where it just doesn't become worth it.
Yeah. Well, we're out of time. So thank you so much for sharing all of this wisdom
Thank you.
with us. And I'll let Martine wrap it up and end the webinar.
Thank you guys for having me.
Yeah.
No, thanks everyone for attending, and a special thank you to Daniel for adding your expertise here. We really appreciate you joining us, and we hope you join us again in the future. I encourage everyone, if you have any further questions, please reach out to us. We're happy to schedule individual sessions and talk through, kind of get you on the path which was right for you. Everyone have a good afternoon, and see you next time.
Thank you guys.
All right. No, it's just